we're joined by Andy McCarthy. He was just with us earlier this week. He is of Fox News and National Review and formerly of the Southern District of New York, where he was a prosecutor for, I think it was 23 years, if I get that right. I'm close to it. Andy, thank you for being back with us. The Supreme Court has made a move, and it could be big for Trump among other individuals. What can you tell us about, first of all, what's the court doing and what does it mean? Andy?
I want to say about probably less than a year ago, maybe around a year ago, the D.C. Circuit got three of these, maybe it was more than three, Capitol riot cases where what the defendants claimed was that the statute, the obstruction statute, did not apply to their behavior and that it was in any event unconstitutionally vague. And this claim, and I will get to why if you want me to, but I think Trump has a better one than they had. This claim so bollocksed the D.C. Circuit, the three-judge panel each judge issued an opinion, and it was hard to tell at the end of it all which opinion was the majority opinion. That's how split they were on the statute. And one of the judges, who's a very good judge, Greg Katsas, a Trump appointee who's a solid conservative lawyer, I think worked in the Bush Justice Department, but he pointed out that the way the statute is written, the nub of it is the word corruptly, which is such a vague term that if you don't have some objective limitations on it, it invites all kinds of prosecutorial mischief. So their claim was that the obstruction statute is essentially about things that you would do to destroy or tamper with evidence at a proceedthat, like witness tampering or fiddling with documents and that sort of thing. And there's a very broad provision in it that says, otherwise corruptly obstructs. And what they were arguing was the only way you can read otherwise there is in conjunction with the things that go to evidence tampering. And it doesn't apply in a case where the claim is that basically, the riot prevented the congressional proceeding from happening at all, that it's not really an evidence tampering claim. Now, I didn't think they'd get far with that, but they got pretty far. And the problem with it is the statute is very vague. And the reason I think Trump has a stronger claim in the end is he's not involved, and we have to keep stressing this. He is not charged with any violent crime. He's not charged with incitement. He's not charged with anything to do with the riot. The claim against him is that he posited a cockamamie legal theory for invalidating electoral votes that he supposedly knew was baseless. That's a real reach. As I've said a number of times, if when I was a prosecutor, Buck, you just referred to me being one a long time. Man, if a frivolous legal theory was obstruction of justice or obstruction of a proceeding, I could have indicted 5 people a day for obstruction.
And you probably would have loved to have that to hang over the lawyers that were opposing you, the defense attorneys, those awful guys. All right, so here's the reason why I definitely wanted to bring you back is as soon as I saw this news, my first takeaway from the Trump angle, and you've raised a lot of really good parts there, is to me there's no way these 2 charges, this is 2 of the 4 charges that are being brought by Jack Smith. To me, there's no way that could go to trial on March 4th with the Supreme Court having a hearing and then going to issue a ruling on whether these are even usable charges, right? So to me, when I read this and this morning when this came out, I said March 4th is out the window. Earlier this week, you said you still thought March 4th would happen. Now that this is added on, how would you assess timing, which is a huge part of this, leaving aside even the legal arguments themselves, but just the time under which they're going to be made?
Clay, I think that we're not going to be able to answer that until we hear the argument that the Supreme Court's going to give Trump in connection, the case that they already accepted, or at least they're pondering whether they're going to take it or not. And the reason I say that is it's not clear to me whether, in order to address the immunity claim, if they decide that they're going to address it, they need to get into the rest of the case or not. But I think if they signal that they're open to getting into the rest of the case, which is, I think, the reason Trump really needed to get this case up to the appellate courts, then I think you're right. It would be very hard to have the trial on March 4th. In fact, if they get into the substance of the charges rather than just the narrow question of immunity, I think it's going to be a long proceeding for Jack Smith. I've always thought that if Trump could get this case up to the Supreme Court prior to trial, he'd have a good chance of beating it, because we not only have that D.C. Circuit opinion that I just referred to, but weeks after that happened, the Supreme Court threw out the convictions of two of Andrew Cuomo's cronies in New York. And that was in connection with a fraud theory. And I think that fraud theory completely blows up Smith's fraud theory, even though it's under a different statute, because what the Supreme Court said in that case is we're very wary of vague terms and statutes and prosecutors basically using their indictment power to write up new crimes that Congress hasn't actually codified. And to me, they were basically saying, we don't want prosecutors doing exactly what Jack Smith has done in this case. In fact, when the court came down with that case, I predicted, Smith can read the tea leaves here. He shouldn't bring a case after the Supreme Court has spoken this way, and he brought it anyway. So I've always thought Trump has a much better chance if he can get up to the Supreme Court pre-trial. I think the politics and everything else will worse for him if he gets up post-trial and he's been convicted, because then they're throwing out a conviction, right? Now it's only about, is this legally kosher, this case? So I think this is a better setting for him, but I don't know. I don't know if they're going to get into the charges this early on.
Andy, how is Trump's legal team that's handling this in D.C., how would you assess them? I mean, I know in the past there was a real effort, and I'm sure it's still ongoing, to prevent a lot of top legal talent from representing or even working with former President Trump. How do they strike you, the ones that are handling the D.C. case? Is this an A team? Do they know what they're doing?
Well, here's some bad news on that score for the Trump folks, and this has been written a few times by my colleague at National Review, Dan McLaughlin. On the fraud count, there is the statute that criminalizes fraud on the government has been on the books for over a century. And the Supreme Court, in a case called Gradwell, in I think 1917 or so, threw out a conviction and said this fraud statute is not intended to deal with elections. That's not what this fraud statute is about. The Supreme Court has never cut back on that decision. They've cited it one time since 1917 in an opinion that Justice Scalia wrote, which seemed to reaffirm what they said the first time. So they've never thrown that out, and that's directly on point in connection with what Trump's been charged with. In the legal papers that they filed to dismiss charges in the indictment, the Trump team did not cite that case. So, it's not like they not only didn't cite it, it's not like, they must have done research and they missed it. We've been writing this since the indictment came out. So it's not like I'm not saying everybody needs to read National Review, but I mean, it's not like it's not out there in the air, So I was very disappointed to see that they hadn't at least cited that case, because it seems to me to be so important.
Last question for you, and thanks for being flexible on this, because this is breaking news, and we're going to talk some more with Julie Kelly. You've been in, as Buck said, federal prosecutions for a long time. This news comes out, and the Jack Smith team, again, on the Supreme Court taking a case that deals directly with 2 of the 4 charges they're bringing. This news comes out, and the Jack Smith team reacts how the Trump legal team reacts how. How favorable do you think it is to Trump, disfavorable to Jack Smith when their legal teams are looking at this and trying to map out their scenarios?
Well, I think hopefully the Trump team is all over it. That's an easier question to answer, Clay, because it's so favorable to them, and it sort of hammers them over the head, I think, in a big way. So hopefully they'll get this and exploit it. As far as the Jack Smith team is concerned, as I said, when that case came out where they threw out the convictions against the Cuomo cronies, I publicly said, Jack Smith ought to close up shop now because the Supreme Court has sent a direct signal that they don't want prosecutors getting creative, like he got creative in his indictment, and then he turned around and indicted him anyway. So, I think what his approach is going to be, as we discussed a second ago, is to try to keep any argument now with the Supreme Court narrowly on the issue of immunity and prevent the court from getting into the substance of his charges, where he's going to have a very hard time. He's in a much better position with Trump if he goes up to the Supreme Court after a jury has already convicted Trump. If he has to argue the case before then and he's indicted it in the teeth of the Supreme Court rulings saying don't do this sort of thing, I think he's going to have a problem.
Andy McCarthy, fantastic. Have a good holiday season, and we appreciate you jumping on short order.
You guys too. Merry Christmas. Take care.
Merry Christmas.